Good afternoon, everybody. The closing of the door ceremony that you just had in the back almost reminds me of when they close the airline door and the person in the airport waves at the person on the plane, and you're on the plane thinking, boy, I hope that's not a melodramatic wave of something to come in the future. But thanks for joining us this afternoon. My name is Crusius. I'm a partner at FedNexus Law, formerly known as Center Law Group. We just went through a rebrand, so everything I'm wearing says Center Law, but the slides and my cards say FedNexus Law. We do, just so you know what we do some government contracts work, and I specialize in internet law. I used to practice with a well-known attorney who did this, not always well-liked, but well-known, who passed away, John Dozier, Dozier Internet Law, as some of you may know him. He unfortunately passed away a couple of years ago, but I used to work at his firm. So anyway, these top 20 mistakes are culled from issues that clients have had through the years. And this is an anecdotal list. It's not an official list, of course, unlike David Letterman's top 10 list, which is very official. But these are the top 20 mistakes that I've seen, at least through the years. And I like doing these presentations because you really get a sense of, believe it or not, helping people, because a lot of times I see the same things happening over and over again where people are making the same mistakes. So if you get the message out, you avoid a lot of those mistakes and avoid having to hire somebody to help fix those mistakes. So there's this saying I love, which has taken a lot of different forms. If you actually go on Wikipedia and look at this, you'll see all the variations that they have, but this is the original statement. Those who cannot remember the past are condemned to repeat it. And that's what a lot of what we do is, and what we do in life is the mistakes we make are usually mistakes that people have made in the past. So the good news for everyone here is you are not doomed, because you're here and you can learn from the past. And some of these things I'm sure you already know, but hopefully there'll be some new nuggets of information that you can get out of this today. So these are the top 20 mistakes that, at least that I've found, that affiliate marketers make. So the first mistake, and this is one that you see time and time again. In fact, I just spoke to a client who's here about this very issue. Not treating your business like a business. It's really important, if you are in the affiliate market business, to not treat it like it's your personal side gig, but to incorporate. You could do that without the need of an attorney. You could do it in a few hours. There are plenty of websites. While people still like to hire attorneys, and we still do that sometimes, people like going through the web and doing it that way, and I think that's a wonderful way to do it. But incorporate. You protect yourself from liability. If somebody has a beef with you online, whether it's the federal government or an affiliate marketer or something else, someone else, if you have a business and you treat it like a business, then you're much more apt to protect your personal assets. The last thing you want to do is go into business for yourself and have your personal assets at risk. So this is a wonderful way, a fairly inexpensive way, to make sure that you're not at risk for your personal assets, that the only thing you can lose is your business, which may be a lot, but at least you're not losing everything that you've accumulated to date. So a caveat there, if you could hear it over the banging in the background. Hopefully they're preparing for the drinks later. But you treat your business like a separate entity. It's one thing to start a new company and have that company and have it there in paper, but you also have to treat it like it's its own separate entity. So the bank accounts should be separate for the company. You should do things like it is its own company. So there's this term of art called piercing the corporate veil. It sounds very fancy, but what it really means that is if you don't treat your company as its own individual company, then you're at risk for being found to do that, and in essence, they'll treat it like you don't have a company at all. So establish a company and keep it separate, keep the assets separate. And it's not that difficult to do, just have a separate bank account, use that bank account, and keep the corporate formalities going, whether it's meetings or whether it's filing statements every year with the state that it is at. That wasn't very funny, but okay. But it's good to have the separate corporate formality. And that way, no matter what you do, at the end of the day, you don't lose your own stuff. You lose their business stuff. So the second mistake that I see is not having the right contracts in general. And this is an overview when you get into this in more detail. But affiliates should have contracts with their networks, and that will help them understand the parameters of what they're doing overall. In every world, including this world, having a written contract is really important. And while that may seem obvious, you'd be surprised how often disputes become really bad disputes because there are no contracts in place and there's no guidelines that people can follow and understand what boundaries they're supposed to go through or stay within. So having contracts on the affiliate side is really important. Also, a lot of times the affiliates are much smaller than the networks. And networks often have their own lawyers. So it's good as an affiliate to have that contract as a protection that you have. So if you ever get into any problems, you have something to rely on. And we'll go into more details about that in a few minutes. Networks need protection from affiliates. Sometimes affiliates, even the well-intentioned ones, go outside the bounds of what they're supposed to do. So as a network, if you have a contract with an affiliate, that does protect the network from liability. For instance, intellectual property violations that you may find popping up from time to time. And I'm going to talk about a couple of those instances where those have crept up. And also, don't be afraid to negotiate. A lot of times affiliates, I find, are too intimidated by the networks or really want to get on board with the network or too intimidated by other parties to negotiate their contracts. A lot of times they're negotiable even if you don't think they are. So reach out and ask to negotiate if you see a term in there that doesn't seem right to you. While you may want to have a lawyer review it, a lot of times it doesn't make sense to do that. So, just read these contracts very carefully, go over them again and again, and really, if you see something in there that's not right, you have a choice to walk away from a deal, and you have a choice to negotiate. And most oftentimes, you can negotiate those contracts. So just keep an eye out for those terms. Here's mistake number 3, and I've seen this actually personally happen a few times. Affiliate networks operating without contracts. And this is a very dangerous game for affiliate networks to play sometimes because you have 3 categories that you should have. One, website contracts that have the outline your terms and conditions and privacy policy. Pretty much these days everyone has some kind of terms and conditions and privacy policy, even if they've copied and pasted it from another website. But it's necessary to have those. I would not recommend copying and pasting them from another website, besides being a copyright violation potentially. Also, those website contracts are not specific to your business. Each business is different in this sense. Everything that you do, we always make the jokes about everyone is a unique snowflake, right? And then there's some mean people come and say, we're not unique snowflakes, we're all alike. Well, the reality is that every affiliate business really is different, and you all have different niches and all different needs. And so copying and pasting website contracts is often a bad idea because sometimes you'll miss something that's really important. I mean, I'm not telling you to violate any copyright law, but if you're going to copy and paste, at least read it through and make sure you can change some things to make it applicable to what you're doing. So that's the first kind of contract that affiliate networks should really have. Contracts with merchants that outline the use of the merchant's intellectual property. We see big fights often in the IP field. So you have, and we'll talk about intellectual property in a little bit, but you have trademarks and copyrights are the big thing in this area. And what can networks use as far as pictures of the product, trademarks, and things like that? Some merchants are a little more stingier than others about what can be used in this sense. So unfortunately, I've seen a few of these disputes, and they can get ugly over time, especially if something goes bad in a deal and the merchant then goes back on the IP use as an out. So how and when the merchant's text, photos, logos can be used, all that stuff is something that should be in a contract, somewhere written, so everyone understands the rules of the game. Because if that happens, it's a lot easier for everybody to move forward, and everyone can make money that way. Also, if you have affiliates in your network that do something wrong, not saying affiliates would ever do anything wrong, but if that, on the off chance that it happened, having a contract can protect an affiliate network. So also, you want to ensure that there's no affiliate wrongs that you're held responsible for. Also, if merchants have given you terms that you need to flow down essentially to the affiliates, you want to do that. So if a merchant says, you can only use my product on this kind of website, you want to make sure that's in all your affiliate contracts, of course. So you're flowing it down from step to step all the way down the line. And that way, your affiliates are on notice of about what can and can't be done. So Also, if the contract that you have with the merchant really changes how you can advertise a product, what venue can advertise, of course you want to flow that down again to the affiliate. So here's affiliates operating without contracts, and this is a fairly common thing, although we do see some really good contracts out there. Of course, as an affiliate marketer, if you have a website, you want to have contracts that outline the terms and conditions in your privacy policy. You're also going to have, on the other side of the coin of what we just discussed, is you're going to have affiliates who don't understand how they can utilize the intellectual property that they're given when dealing with merchants. So in essence, as an affiliate, you really want to know, like, how can I use this picture, when can I use it, and what context can I use it, and what kind of websites can I use it on. Same thing with the text and maybe the logo of the product that you're trying to sell. So one thing to note, though, the network or the merchant might try to obtain some kind of legal indemnification, which means that if you do something wrong, you'll be responsible for your own actions. And this is, again, why it's really good to incorporate. And when you sign these contracts, you want to use, of course, the name of the company that you've incorporated, not your personal name. So that way, if there's ever an issue down the road and there's a breach of contract action, or there's some kind of intellectual property issue, which can be very expensive, it's the company that would be at fault or at risk and not you personally. And that goes with every contract that you sign. Incorporate first if you haven't already, go do it soon, and then use the company name when signing these agreements. And that way you protect yourself and your personal assets going down the line. So also, you may want to have contracts if you have employees or 1099s or consultants. If they're doing things to help you out, helping drive traffic or working for you, if it's not one noise, it's another, then they can understand the bounds of their relationship with you. The IRS and the Department of Labor is really cracking down on who's a 1099 employee, who's a regular employee. So if you classify folks as 1099s, which means that they're essentially independent contractors, you want to make sure that those folks are really 1099s. So there's online tests you can take if you like, but the question that is most relevant is, does this person have control over their own time? Are they really an independent contractor, or am I controlling them on a day-to-day basis from 9 to 5 essentially? And if you are, they're probably really an employee and not a 1099. And what happens is if they complain to, let's say, the Department of Labor about that, because then they're entitled to get taxes and things like that, the Department of Labor will investigate, and oftentimes they'll bring in the IRS because it's also a taxation violation. Or if somebody complains to the IRS or the IRS gets wind of it, they'll bring in the Department of Labor. I was at a listening session once where they were talking about this, and they like to tag team. So it's the two of the least like government entities in the country, IRS and their Department of Labor at the same time. So just be very careful in that area. It's not something that people are usually concerned about, but if it goes bad, it can really go bad. So just keep an eye on that as far as workers that you may have under your employ. Sure. We just want to get you a microphone, I think, because it's supposed to be, or I want you to ask me and I'll repeat the question.
Okay. How about workers overseas, like freelancers, outsourcers?
So the question was if there are workers overseas, freelancers, outsourcers. I wouldn't be too concerned with them at all, because these Department of Labor and the IRS really cover U.S.-based activity. So if they're overseas, you can do what you need to do. Yeah.
Just to follow on that, what if it is someone based in the U.S. or Canada or something like that, where you use no-desk ELANs, one of those resources?
So what if it is somebody based in the U.S. if you use Elance or another service like that? I wouldn't be too concerned with that, because if you're using those services, it's essentially implied that they're independent contractors. On the same token, is this a service where you're actually you're paying the service instead of the individual directly, or are you paying the individual directly?
Yes and no.
Okay, yes and no. If you're paying the service directly, I would definitely not be concerned at all. But just look at, I have little concern over that issue, but just look at how you're treating them as far as whether they work for you 40 hours a week all the time. Then they move more into the employee role than if they're part-time. So any other questions about that? Oh, looks like it advanced on its own, or I did that already. Trademarks. There's a slide actually that's forward here, and I'm actually going to start with that. I did this presentation when I was pretty tired. Here's an important reminder. Intellectual property is everywhere. Everything in this room that you see has some form of intellectual property attached to it. This microphone is protected by a patent, as is this computer. The logo, and by the way, there's a mistake on the slide that should say trademark law at the bottom. So whether registered or not, logos can be protected by trademark law, not copyright law. So any logos are protected by trademark law, and any text that's created, any picture that's taken, any kind of work of art, even if a picture is a rote picture of a product, that is protected by copyright law. And nobody has to file anything with anybody to get copyright law protections. It happens automatically upon creation. So the words that you write down, the notes that you're taking about this presentation, that guy is really crappy, or that was the best presentation I ever went to, or somewhere in the middle, those words are protected by copyright law. You don't have to march down to the Copyright Office to do that. So if you see text online, it is protected by copyright law. If you see a picture online, it is protected by copyright law. If you see a trademark of any kind, that is protected by trademark law. And again, you don't need to have registered it in order to have it protected. Lawsuits have been brought and can be brought to unregistered trademarks and copyrights. So just be very wary when you see something and understand that everything around us is protected by some kind of law. Even this carpet, whether you like it or not, and we all have probably our opinions about it, is protected by copyright law. The design can be. So first one we'll talk about is trademark use and failing to understand the proper trademark use. In this business, I think it's a really good idea to go online, get just even a 15-minute crash course on what trademarks are and what they mean. Even if you want to glom it off our website, if you go to fednexuslaw.com, I'm still trying to remember that, but if you go to fednexuslaw.com and there's an Internet and Technology law under the practice areas right to the right in the front, you click on that and there's a spot to go to trademarks. There's a long diatribe on what trademarks are. And it's very helpful just to even read that, just to see if you don't have a familiarity about the different aspects of trademark law. And it's written in plain English. And I think it's a very helpful guide because if you're in this business, you have to know and understand, of course, the proper use of trademarks and when you can use somebody else's trademark and when other people can use your own trademark. If you have your own trademark that you want to protect, of course, and you see others using it, then that's an important thing to protect. Because if you fail to protect it, the trademark, USPTO, United States Patent and Trademark Office, or courts will say that you've abandoned your trademark. So just keep an eye out for that. But for the network and merchants out there, affiliate contracts should have how and when to use the trademark. Obviously, if you are selling Disney stuff, you don't want your trademark used on pornography websites, or that would not be good for them. So different things like that, you may want to limit where your trademark can be used. And that may be more basic on where the ads are being placed or what kinds of websites are being utilized. Also, affiliates should look at their contracts to understand when and how they can use their trademarks or the trademarks properly. So here is a deeper look. This is what trademarks include: logo, name, and trade dress. Trade dress is essentially like the packaging in a product or an identifying part of the product. Like the installation in a home with the Pink Panther, the pink installation, that is considered trade dress. Or the Coca-Cola bottle, its unique shape can be considered a trade dress. And, or the logo name, of course, Coca-Cola, or the fancy logo or the Nike swoosh, those are all trademarks. So those are examples of things to look out for. Copyright use. Again, we have the same thing on our website if you're interested, or go to lots of websites that are out there that have the basics on copyright law. But again, it's just going to the deeper look. It could be a lot of things. You have text, you have software code actually, underlying HTML code, pictures, images, all are protected by copyright law, and they're all protected upon creation. Now, you get more protections if you register it. So if you have copyright, something copyrighted that you want to protect, then of course go ahead and register it with the Copyright Office, because by doing so, you have essentially, if you need to bring a suit of any kind in the future, you have a rebuttable presumption that you have a valid copyright. And that's one step of the case you don't have to worry about. Also, then you could get your attorney's fees back, and you could get statutory damages. So you have a lot of benefits to registering copyright if you're a copyright holder, but you don't have to do so if it's not worth your time or money to do so. So I'll give you an example, though, how easy it is to violate copyright law. I had a client who was starting a merchant website, which developed into a very large website. And when he was getting started, he copied and pasted a bunch of pictures from a competitor website of product shots. They were straight-on product shots without any kind of special thing done to them. They were just the product in a white box picture on the website. And the client copied and pasted those onto his website, so he had product shots for the same products he was selling. So the competitor saw this, and as our client got bigger and bigger, saw them as a threat, so they filed a lawsuit alleging a Copyright Act violation. And the court essentially found that there was enough creativity in those product shots to warrant copyright protection. And the case wound up settling, but the result was lots of attorney's fees and lots of litigation between two fierce competitors because of that copyright violation many years ago. It wound up being a couple hundred product shots. It was nothing special or fancy or anything like that, but in the end, it cost him a lot of money to defend this copyright lawsuit, because at the time that the lawsuit was brought, he had a very valuable business worth protecting. It's not something he could walk away. Thankfully, he was incorporated, so there was no issue with personal liability. But of course, he fought it to the end and eventually settled it because he saw it as an issue that was very important to protect his company. But he had no choice but to fight this lawsuit because it was brought, and there was some validity, at least according to the court, in the lawsuit. A second part of that lawsuit, going back to trademark, they also accused the client of the merchant of using the trademark name in the website code. Now, everyone knows these days that website code doesn't really drive traffic to a website. But the judges in federal court are not so educated on the fact. Most of them are not tech savvy, and most of them have non-smartphones, from what I've seen anyway. So explaining affiliate marketing to them and website code and anything that starts with the letters HTML is not an easy task. So eventually those claims were dismissed, but it took some time because, wait a minute, I thought Google picks up on all these things, kind of thing, and well, it really doesn't. We were close to having to bring in an expert from Google or something like that to show the judge that they were wrong. But anyway, these are easy things that you can do. When you're sitting in front of your computer, you don't think it's a big deal. And oftentimes it's not a big deal. Nobody notices, nobody cares. But once in a while, it becomes a big deal. And those big deals are expensive big deals. So the easiest thing to do is to take your own product shots or get permission from somebody to use their product shots. And then you don't have this issue. Because in the end, that competitor was not hurt at all by the use of these photographs, right? There was straight-on product shots. Anybody and their mother can take them. They used a very low-level digital camera. I think it was like a 3-megapixel camera. And a $30 box, white box with flash. So whether you think it's a problem or not, just be very extra careful about these things when looking at these possible pictures or text that you want to utilize. And that's the reminder we already spoke about. So mistake number 7, not being honest with advertising. It's easy to push the bounds in advertising. I could tell you I do the marketing for our law firm, and a lot of it's online. And there's always that push, even internally, to let's push the boundaries just a little bit further and a little bit further. But in the end, it still has to be honest, no matter how far you push the boundaries. And of course, I'm constrained by bar rules, or else those lawyer ads that you see on TV would be even worse, if you can imagine. But you have the FTC as your bar, essentially, and if their ads are not honest in some way, shape, or form, the FTC may take notice. I don't have this mistake in here, but of course, you have the Child Privacy Protection Act that was passed or instituted last year, and that's a similar thing where the FTC is really being aggressive. If you market to kids under 13, or you have websites and know that kids under 13 will be utilizing the websites, before you take any information from them, and an argument is that includes cookies as well, tracking, you have to get permission from a parent or a guardian to do so. And of course, the likelihood of, the difficulty in doing that can't be understated. So, but with the FTC in general, you want to monitor the claims that are being made by, if you're an affiliate, you want to be careful about what you say in your ads. If you're in a network, you want to essentially monitor, if you can, what your affiliates are doing here and there. And of course, marketers and OEMs, manufacturers want to be careful about how their products are being represented, because in the end, people associate the product with the problem. So if you have an affiliate marketer, if you're a merchant, you have an affiliate marketer selling something and claiming it does one thing when you never claim that yourself, but they'll connect the product and the claim together, and they'll think you're the one doing it, of course, because we were having a discussion at lunch. 99% of the population out there does not understand what affiliate marketing is. They don't know what affiliate marketers are from a hole in the wall. So if you're a merchant, the danger is, of course, that the public will view you as essentially standing in the shoes of the affiliate marketer. So also, these are the biggest trouble areas here: deceptive formats with the fake news stories. Of course, you want to disclose that they're news stories, false endorsements, and unsubstantiated claims. There's a laundry list, of course, of problems that can crop up, but those are the big ones that I see, at least, when I have clients come to me about this. Free trials. I don't know if anybody here has ever dealt with the free trials. I think they're a terrific way for customers to get a taste of the product and understand what the product does and how they do it, and verify that they want to invest more in the product. And for the person selling the product, it's a wonderful way to get more customers on board. Now, the problem is with the free trials that happen sometimes is the difficulty in a customer in returning the product or not extending the free trial. And it's always in the fine print. So you have instances where somebody purchases a product or pays for shipping, maybe shipping and handling, $295, $395, $495, gets the product, uses it a little bit, decides they don't want it, tries to call the company back to return it, cannot get through. Tries over and over again, cannot get through. The next thing that customer is going to do is they're going to complain, usually to their state consumer board of some kind, or their state attorney general. Same thing, customer returns the product, maybe their credit card keeps getting charged, can't get through to the folks selling the product. And again, if they can't get through, they will complain, and we see a lot of complaints to the different states' attorney generals. So these are the questions that a lot of times the AGs will ask, attorney generals will ask. Is it necessary to return the product to avoid the charge? How easy is it to return? Is your line being staffed by an adequate number of people? Different things like that. So if you do the free trials, just be wary about how you put your disclaimers and how big they are, and ensuring that folks can return products. Because the problem with the state attorney generals versus the FTC is that there are 50 of them, 51 if you count DC. So these things can come in fast and furious, and to respond to them is a very difficult measure. And in the end, all you're going to be doing is refunding their money. But the problem arises when the state attorney general sees a pattern. Luckily, they don't really, for folks in this position, they don't really talk to each other. So if you have 3 complaints on one, 2 complaints on another, and 1 complaint for 30 other states, those 30 other states might not realize that there was complaints from the various other states. So it might be easy to kind of give a refund, respond in a short letter that a refund was given. Sometimes, if they think it's more serious, they have a lawyer respond, because a lot of times you find the attorney generals will take it more seriously, and if they see that you're taking it more seriously, and then back down. But what you don't want to do is have them open an investigation against your company because of these returns. And if they see a pattern of returns, or see a pattern of problems with the returns, I should say, then you'll see more and more attorney generals getting involved in the situation, and they could launch investigations. And when that happens, then other attorney generals can pick up on it because they hear about it through the grapevine, or it's published on the website of the AG's office or Consumer Protection Board, whatever the mechanism is in the particular state. So canned spam. I don't see canned spam, and I'm sorry for the typo in the middle of the slide there. Almost looks like C-SPAN. Canned spam is not a huge problem at least that I've seen in practice. I don't know. It's very easy. I mean, people joked around when it was passed that the Canned Spam Act was the Now I Can Spam Act. because it's pretty easy to get through the requirements. And you can see them here. These are the biggest ones. But accurate, you want to have accurate subject lines, the ability to opt out, using email addresses to send obtained with false information. I mean, these are very basic things that most companies will do anyway. So, you know, if you just go online and do a quick search for the CAN-SPAM Act and see the basic 6 or 7 requirements, and the most important ones are in the slide, you should have no problem complying with it. But spamming used to be a much bigger problem. I'm not seeing it being a huge problem right now, at least for US-based companies. The spamming has gone overseas where there's little that anybody can do about it. Bad AdWord campaigns. This is another issue that we've seen weave through the courts. It's been pretty interesting to watch, actually. So in the olden days, about 4 years ago, there was a different take on this. And it's gone back and forth. So when you buy AdWords, and how many folks here actually engage in AdWord campaigns or alike? Few. Just about everyone who's here. So if you buy AdWords, it used to be that you could, then you couldn't, now you kind of can again, buy the words of your competitors, keywords of your competitors. So you could buy a competitor's keyword, and it would cue your ad to come up when somebody searches for your competitor. Now the courts are split, I'll be honest with you, about whether this is proper or not. I would shy away from doing it because there's always a chance. It's still an area that I think is very much in flux. I've handled some cases in this area, and I've gotten different results from different courts, which is a little bit of a frustrating experience, more so for the client than for me. But it's really frustrating because you want to have something to rely on. I mean, this is actually something I feel like the Supreme Court should take a look at, whether you like them or not, because at least you'll have a uniform rule around the country. Because here you have some courts saying it's okay to use somebody else's trademark as a keyword to cue your ad, and some courts say it's not. One thing that you cannot do, definitely, is use somebody's trademark in your ad if it looks like that it's representing that competitor's product or service. So I have that issue right now in a case where you know, you have what's called in the trademark land initial interest confusion. And if potential customers are initially confused about the source of the goods or services that's in the ad, if they think it's that company and not yours, then that would be probably some kind of trademark violation. So just be very careful if you're going to, yeah.
Just a clarification on that. I understand that you wouldn't want to use the keyword, competitor's keyword in your ad, but if you're using a phrase match, it would show up oftentimes under their search phrase. Like, you know, if someone types in the competitor that you're targeting perhaps indirectly,
Yeah.
it might show up and it looks like you're targeting that keyword, but really it's a phrase match.
Yeah, so the question was about the phrase match, how sometimes, you know, if you're typing in the phrase, it will show up as a match. And actually that was something that came up in one of the cases I handled, and there was essentially criticism of one of the parties for not doing that. You know, I could see the benefits both ways, but yeah, I think that's a really good point. Any other questions about AdWords? Using others' photos, we actually already talked about this, but straight product shots, often very copyrightable. Violations of the Copyright Act can result in statutory damages and attorney's fees. So here's mistake number 12, and we'll move this along because I am running a little bit behind. Merchants that do not understand the risks. How many folks here are merchants? Are there any merchants here? Okay. So here are the risks that you see, and of course these are unique situations where this is not the rule of what happens, but these are the things that possibly could happen. And here are the fix. One, you want to have iron-clad contracts. So your contracts should include indemnification clauses, and try not to overreach because you want them to be as effective as possible. The less that they're overreaching, the more effective they'll be. Of course, monitor networks and affiliates. Make sure that they're complying with your contracts and the various laws. And research who your partners are, who you're doing business with. More and more so, the way the government operates, they go through this whole guilt by association thing. And if your partners or folks you're dealing with are essentially guilty of something, they'll think that you're doing something wrong too, just by virtue of your association. So look for companies who are known to have good business practices, or at least avoid those who do not. So that's one way you could stay out of trouble. Mistake number 13, you see a theme here. Networks who do not understand their risks. And again, the fix is, of course, I'm a big contracts person. I think spending a little time in the front end is worth a lot of heartache in the back end. So, even if you draw up the contracts yourself, have something in writing and have it in stone, so that way if there's ever an issue down the road, you know what the rules are. And having those contracts will save you so much heartache and so much time and so much money in the back end. And, I often talk myself out of a lot of work by doing that, but I think it's the right way to operate, and I think it helps people have successful companies. Of course, the second one, monitor affiliates to ensure that they're compliant with the various laws. And the same thing, research who you're using as an affiliate. Do you know of them? Do they have a good compliance history? What's their reputation like? It's a fairly small community. So what do you hear in the community about them? And affiliates. And these are the risks, and we spoke about some of these that affiliates have: misappropriating intellectual property, drawing the ire of the FTC. Maybe you're advertising a product that does not work like the merchant said it would. Those are all risks that you have. So, of course, the basics, the first thing that's actually not on the slide is to incorporate and evaluate every contract before you sign it. So even if you're not going to try to change any contracts, understand what it says, understand what it means, understand what you need to do to comply with it. And by doing that, you'll know the rules of the game moving forward and what to do. Of course, you want to try to ensure product claims are accurate. I've talked to some affiliates who actually purchase the product and use it and see if they like it. You don't have to go that far, but you want to make sure that the claims that you're making are accurate, at least according to the manufacturer or the merchant. If there are any terms of contention, so any terms that you have that you think should be changed, you want to try to negotiate those. Sometimes they are negotiable. And make sure your advertisements comply with the FTC and you're complying with canned spam practices. So when I spoke last at Affiliate Summit West 2013 and did a somewhat similar presentation. And one of the biggest risks I've found, believe it or not, is the enemy within. So if you're a solo company, unless you have a split personality, you're yourself, and that's it. You don't have to worry about an enemy within. But lots of companies that have multiple people have these issues, especially small companies, believe it or not, where you have partners fighting with each other. You have different issues that can come up that require outside assistance. You have employees who just go crazy. It does happen. I've seen it happen too often. So being prepared for that and understanding what the risks are a good way to save a lot of heartache in the end. So, and I say in the slide here, companies of all shapes and sizes are vulnerable to rogue workers and business partners. And I used an example a couple of years ago when I was talking. At that time, it was January of 2013, my wife was about 6 months pregnant. And I told a story like this. When I found out she was pregnant, I was elated, excited, and I was also became incredibly nervous. What's going to happen with the baby? I can't even see the baby. Is everything okay? And I looked up everything that could possibly go wrong, and it was a list of a parade of horribles, of course, because anything that goes wrong now is on the internet, right? So you see all these terrible things that can happen. And you realize that the baby, while has some strengths, is very vulnerable, even though it's in the womb. And I viewed a company, especially one that's just starting, the same way. You're really trying to get out there. You have some strengths, but you're really vulnerable to a lot of outside forces that can happen, and even internal forces. Like a fetus in the womb may have issues with the chromosomes or something like that. A company can have issues within, between business partners or with employees. I represented a company where one employee nearly destroyed the company a couple years ago. And that employee was just somebody who worked in HR, but they began spreading information out to the general public, information that they were not entitled to spread, of course. This person had their company BlackBerry and utilized, until it was turned off, utilized that company BlackBerry to spread information around the world. about infighting within the company, business relationships where the company had been critical of a business partner. Internally, of course, that happens. You're going to have critical emails of a business partner internally, and then she forwarded those emails to the business partner. So that was obviously not good for the company and nearly drove it out of business. But a couple of simple steps could have saved something like that. For instance, being proactive about turning off the BlackBerry quicker, doing a background investigation. When you hire somebody, there was no background investigation done of this individual, and if they had done one, they would have noticed that she had been in trouble before, and they would have not hired her. Dealing with the situations up front. If you have employees who seem to be difficult, dealing with it up front, giving people their bounds, and don't be afraid to let somebody go. They should have let, this sounds a little bit harsh, but they should have let her go much earlier than they did. They were trying to be kind and bring her along. But she had displayed tendencies like this before. Her father had died twice during her tenure at the company of about 8 months. She had forgotten the lie that she said about him being dead. We unfortunately had to go to trial in this case against her, and we had her father as a witness. He was very well still alive. So there are different things like warning flags. If you get a feeling that there's something wrong, there probably is something wrong. And in the United States, we are in at-will employment unless there is a union involved. So you can hire and fire people at will. Now, I'm not saying this to go and fire everybody as soon as they do something wrong, but what I'm saying is just to be very careful. And if your gut tells you something, there's usually something there. So other things to look at, business partners who steal trade secrets, so you want to have non-disclosure agreements and things like that, maybe non-compete agreements with employees. There's corporate takeovers, of course, hacking that occurs even by business partners against the business, and go loco, that was the employee I was talking about. So just be vigilant, have the proper agreements in place with those folks. And just to go back in time, this was a picture I used in the previous presentation. Looks like an alien, as they all do, in the womb. And then this is her last month. So she made it. And I was nervous for no good reason, apparently. So anyway, you also want to protect yourself from external enemies. Yelp, and there's other review sites out there that where people can lodge complaints. And the power of an individual to take down a company, essentially, or to really criticize a company and have it be known is tremendous these days. I mean, one bad Yelp review can really be the death knell if people pile on. And it gets out there, if it breaks through social media onto a website like Gawker or something like that, or BuzzFeed, all of a sudden, you have a company that has shut down their Facebook page because they can't handle all the complaints they're getting on their Facebook page, or has to disconnect their phone lines or something like that. So I don't know how many folks here are familiar with Ripoff Report. That's another website that does these things, and people can write a complaint. There's no verification of the complaint. They could just post it on Ripoff Report. Ripoff Report has tremendous SEO. So if somebody complains about your company in Ripoff Report and spells it properly, it often will show up very highly in the Google search rankings, or Bing, or Yahoo, which use the same background code. But if you have a complaint on Ripoff Report, the founder of Ripoff Report, Ed Magnuson, will not take it down, but he requires companies to enter in what's called a corporate compliance program, and that requires you to pay some money to Ed or his company, Ripoff Report, and in doing so, he will investigate your claims and then put something on front of the complaint that says that they have investigated the claims, and so is a good corporate actor. Now, this has been challenged in court. I've not been party to these suits or attorney in these suits, but him doing this has been challenged in court, and he has successfully defended these lawsuits. So he remains in business and striving to this day using his business just because he has very good SEO. Google has shut him out a couple times and delisted him, but he always manages to get back on. He's very resilient. So anyway, if you're on Ripoff Report, you really don't have the option of getting it taken down. Yeah? Oh. Yeah. So the question is, what happens when you have essentially competitors using these review websites to criticize your own company to the benefit of theirs? And the answer is that they're not supposed to be able to do that. And if you know of them doing that and they're saying things, twisted is one thing, but is it false? If it's false, you can sue them. I'm not saying that's the best thing to do or that's what you should do, but you can sue them if you know who they are. And those suits are sometimes successful. Now, a lot of times it's just not worth it. But each website has its own policy. There's one called consumer complaints or something like that where they're based in Eastern Europe and you can't do anything about it. But you can, if you know the person posting the information, you could certainly write them a threatening letter yourself. Maybe if you have good SEO, post something on your own website about it. Of course, you're drawing, Streisand effect, you're drawing your own attention to that problem. But those are a couple of options that you have. It is actionable, certainly. So and here's an example, Harvard Risk Management. If you look at their name, it's not very clear in this slide, but I think the second result is Ripoff Report after their own website. And this is the Ripoff Report. CEO pyramid scheme. That does not do good for your business when it's being called a pyramid scheme. And the second result, it may have people shy away from your business. So that's just an example of Ripoff Report. Also, pay attention to Google autocomplete. So I'm not saying anybody should sue Google over this, but this is something that's just ripe for some kind of action. This has actually been found to be unlawful in parts of Europe, Italy and France. But the US has different laws, of course, and nobody's really challenged it in a very strong way. But you have a situation where it's a self-fulfilling prophecy. So if you're a business, people keep searching for your business, and then all of a sudden scam pops up, they click on scam, right? Because that's the first thing I would click if I saw that. And then that's the self-fulfilling prophecy. The scam moves up the list, and all of a sudden the scam is at the top of the list when they type in your business. So all I had to start typing was ACA, for Accaberry, and scam was the fourth result. So this is something that Google does in their algorithms that they can control. And if there's anybody here from Google, I'm sorry, I'm not telling anybody to sue you. I'm just saying maybe you should look at this and avoid these terms that are like that. They did take scam off for a while, for about 6 months, and then brought it back. So last I checked, it was back in force. But this is, of course, based on an algorithm very similar to the Google search results. Now, Google will argue, of course, that they are just the messenger. They are not creating content. I would argue that because it's a self-fulfilling prophecy, they are creating the content. Because most of the people that click on scam, if not all of them, are not actually typing in scam. They just see it and they click on it. And of course, watch for dedicated hate websites. This is the one actually lodged against John Dozier. Just keep a lookout. You probably do it already, but do Google search, Yahoo search, everything on your name, your company, and do that regularly to make sure there's nothing out there that you don't know about. Of course, Google has an alert that you can set for certain terms. Of course, do that. Not utilizing best practices. If you have employees, train them on what to do, what not to do. Register your name, of course, on social websites so somebody else doesn't beat you to the punch. It's very hard to get those undone once that's happened. Look at the common TLD extensions. Of course, there are more and more now that you may want to register your name in. If you have a copyright or a trademark worth registering, go ahead and do it. You don't need to have a lawyer to do that. You could do that on your own. And it's relatively inexpensive, especially if it's something that's important to you. As I said, monitor Google and engage with complaint websites. You don't want to leave those complaints alone, so it's always good to try to at least engage with them and see if there's something that can be done. Mistake number 20, being afraid to ask for help. Here's a dirty little secret in the legal industry. Most lawyers will talk to you for free, and a lot of times you'll get the answer to your question just by talking to them for 10 minutes. And most lawyers will not charge you for that time, or they shouldn't anyway. So if you have a friendly lawyer who you know and trust, go ask them the question. And they'll probably answer what you need to have answered, and you can move on. Now, of course, if there's something that needs to be looked at, they'll probably charge you for that. But if you have a basic question about how something operates, like any questions that you ask me here, most of the time that's free help. And here's the Just Do It slide. These are just best practices that I use and recommend that clients use. And it's kind of the theme of what we talked about today. But just make sure the claims are accurate, monitor compliance, random internet searches, have contracts, make sure your IP is protected, have agreements with all parties, and check state regulations. There are 50 state AGs out there, so when making claims, of course, that's usually an FTC problem, but you may want to just make sure there's nothing else out there that you don't know about, because there's also unfair business practice laws in every state. But generally, if you're complying with the FTC, you should be okay with just about every state. And handle defamation on the internet immediately. There's nothing that sinks a business like having a terrible web presence. I have one friend who's general counsel of a fairly well-known web company, and when he started there, about half the results in the first 2 or 3 pages were very negative. And he's since cleaned up the entire bad results for the company. And I don't think it's a coincidence their sales are up. They've almost doubled since then. So I think that has a lot to do with it. And they've actually gotten celebrity endorsements and things like that, because when people are looking for them, they don't see the first thing that they're a scam. So those are just some really good practices to help you expand your business. So that's the presentation. I will stay after if you guys have questions. But I thank you for joining today, and hope you enjoy the rest of the time here. Thanks.